Hello, everyone, and welcome to the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 193 of the Forge of Freedom. Today, I'm thrilled to have a special guest back on the show. He's no stranger to our listeners, a former prosecutor, a former criminal defense attorney, and current Superior Court Judge Dustin Houchin. For those of you who are new to the show, Judge Houchin is a returning guest. He first joined the show on episode 27 to discuss crime and punishment and the retributive theory of justice. He returned on episode 103 for a critical examination of problem-solving courts. And if you haven't seen those episodes or heard those conversations, I highly recommend going back to those to check those out. I'll link to those in the show notes. Judge Houchin currently serves on the bench in Washington County, Indiana, a position he was elected to in 2022. Before that, he was the county prosecutor for 16 years, and before that, operated his own law office where he worked in criminal defense. He and his wife, Congresswoman Erin Houchin, are from Washington County, Indiana, and have 3 children. Judge Houchin is also the author behind the Judex Substack, where he writes about judicial philosophy, separation of powers, and other topics related to our justice system. And that brings us to our topic today. Judge Houchin has recently published an incredibly deep and thorough series of articles on Judex titled Making Bail. In this series, he frames the entire history of bail, not just as a legal procedure, but as a modern day effort to solve humanity's oldest problem, how to balance order and chaos. From the world's oldest creation myths featuring gods of chaos like Tiamat and gods of order like Marduk, to the courtrooms of today, Judge Houchin argues that every bail decision is a microcosm of this eternal struggle. A judge must balance individual liberty, which can be chaotic, against public safety and order. Today, we're going to dive into that series. We'll explore the deep historical roots of bail, which for centuries emphasized public order and justice for victims. We'll discuss the rise of individual rights, how the U.S. Constitution addresses bail, or more accurately, how it doesn't create a right to bail, but only prohibits excessive bail. And importantly, we'll examine the modern third wave bail reform movement that, as Judge Houchin argues, has pushed the pendulum squarely to the side of chaos, often relying on misplaced legal and political arguments. We'll discuss how this movement has played out nationally and here in Indiana, the consequences we've seen, and the signs of hope that the pendulum may swing back toward more order. Without further ado, Judge Houchin, welcome back to the Forge of Freedom.
Thanks, Alex. I love to do this. It's our third time here, and it's a real pleasure. So thanks for having me.
I read your series as it was coming out in installations. I think you had 9 installations in the series. And then as I was preparing for this podcast, I reread it, and you obviously put a ton of work into this. But in the series, you framed the history of bail not just as a legal procedure, but as an attempt to solve humanity's oldest problem. Like I said in the intro, this balance between order and chaos. Can you sort of dive into that a little bit and explain this core concept to our listeners?
Yeah. So, one of the problems humans have to solve for is survival. It's a bit of a chaotic universe. Not that there's not order in the universe, but it's a dangerous place for people to be, right? So from our earliest societies, we're trying to build order, a sustainable order to live within. And so you have to solve for problems that creates. And some of the problems are chaos creating individuals. Societies have had to solve for people who don't abide by the norms or customs or even rules of society or laws. Or they can disrupt the entire society. And so when you look at historically, some of our oldest creation myths are talking about building order out of chaos or creating the universe out of a void or out of a chaotic environment. The oldest creation myth that you alluded to is ancient Sumerian creation myth which described the struggle between the gods, Tiamat, who's the god of chaos, and Marduk, who's the god of order. So they postulate that the universe was created out of this battle between these two concepts. You have it's similar to the yin-yang concept in the Eastern religions. God created, in the Christian religion, God created the universe out of nothing, out of the chaos of the world. So this is a theme that seems to be inherent in human thought And so but the oldest recorded one is the Sumerian gods. And so that theory is those two gods fought each other. Of course, the god of order won and created the universe out of the body parts of the god of chaos. And so I use that as a analytical framework to start with that story, because it's an interesting story in the article, to kind of draw readers in initially, but also to serve as an analytical framework for thinking about bail decisions and why we have bail, and that we are trying to balance the chaos of individuals and sometimes their actions with individual liberty. So that's the framework we put on it.
Yeah, and I really appreciate your framework, because I think it carries, you do a nice job of sort of utilizing that framework throughout the series to help understand what the purpose of bail is, and then also to help understand what these sort of various reform movements have tried to do throughout history. And we'll get into that in a little bit. But we were talking pre-show. I like this framing, this order and chaos framing. I think it's a powerful way to think about bail and the justice system even more broadly. But I do have some qualm with equating chaos with liberty, and I know you and I actually agree on this to some extent. But I want to sort of draw this out at the beginning before we get too far into this discussion. And I want to get your thoughts on this. To me, liberty doesn't necessarily equate to chaos. I think liberty, there's sort of this emergent order or natural order. Hayek comes to mind, but others have argued that people who are free tend to develop systems of cooperation, voluntary cooperation, and norms and responsibility without needing this sort of top-down control that we ordinarily think of is provided by government. So in that sense, liberty is sort of this default condition, and the state's role is not to suppress that liberty, but to apply the lightest touch possible, at least in my view, refining or sort of correcting the imperfections of the emergent or natural order from liberty. That's very different from saying that liberty is necessarily chaos. And I know that's not what your point is, but could you talk a little bit about that and how you view this framework of order and chaos and how it relates to liberty?
Yeah, absolutely. So it's perceptive of you to have that thought about it. I had that thought when I was writing it, and I struggled a little bit to delineate that in the piece, what I'm talking about. I agree with you that there is an emergent order among human societies, that there's an emergent order in the universe. There clearly is order in the universe, naturally. If you throw a group of humans together, they will create an orderly structure to cooperate and survive and prosper. No question that is sort of a priori in a human society. But it's also true that there's a lot of chaos in the universe, and there are also chaotic individuals. And so the comparison I'm trying to make is that the very extreme end of liberty, what I would call the very extreme end of liberty, totally unfettered liberty, can allow chaos of the universe or chaos of certain individuals to destroy the emergent organization of the vast majority of people. So when I say liberty in this document, I mean, or when I say chaos and I equate it to liberty, I mean the very far end of the liberty spectrum, if we want to say it's a spectrum, to those people or those things that are completely unordered and can cause problems to the society. There's a concept that has developed over time, maybe mostly American concept of ordered liberty, which you were hinting at. And then I think you can argue about how much order, what's the lightest touch, how is that defined? And that's ultimately, in our world, a judgment decision by the judge. What's the lightest touch I can do to take into account all the factors that I need to take account here. So good point. Absolutely. I think I agree with you almost entirely. And I hope the people that read this and the people that hear this will understand when I'm equating liberty to chaos, I would be talking about completely unfettered liberty that devolves into a chaotic situation at the very end of the spectrum.
Yeah, because as you know, and so many people know, is that in excess, the other direction is even worse, or arguably even worse.
Yeah, right. or yeah, and I talk about in the piece that if you go back, especially Middle Ages, was too heavily on order. That's why we had the rise of individual rights. And I know we'll get into all this, but too much order is tyranny, and we certainly don't want that. And I prefer to err on the side of too much liberty, certainly.
Yeah.
as a
And
society.
so in our discussion about bail, we're really trying to talk about the role that bail plays in striking this balance between too much liberty and too much tyranny, or too much order and too much chaos.
Correct. Right.
So your series goes back, as we've alluded to already, hundreds, even thousands of years. If you would tell us, what did bail or its early equivalents look like in early societies, and what is its primary purpose? I guess maybe start out by saying, what is bail? What did those early forms of bail look like?
Okay. Yeah. So to describe bail first, bail concept comes out of you're bailing someone out of jail or bailing them out of a situation like you would bail water out of a boat or something. So that the term is that it gets confused a lot with bond, and people use bail and bond interchangeably. They don't mean the same thing. Bond can be a term of bail. To get bailed out of jail, you might have to meet these certain terms, one of which can be bond, one of which can be maintain good behavior, it might be check in with probation, things like that. So bail is just the process or the means by which someone receives freedom from incarceration after a probable cause finding that they should be incarcerated. So that's what bail is. Bail is a innovation that developed over time to solve some problems in the justice system. So before I talk about that, I think we have to go back even further to sort of pre-society or prehistory tribes, really. So there's some legal theory that's developed and goes to our first point about there is emergent properties within humans, within the universe, that causes spontaneous order. Humans have some evolved tendencies to do this. So one legal theory that's developed is that there are mechanisms within humans to suppress behavior. This is often referred to as first-party punishment, second-party punishment, and third-party punishment. Okay, so I'm going to describe what those are. First-party punishment is you punishing yourself for something that you did wrong, which we would call like a guilty conscience. So it acts as a deterrent that you apply to yourself to keep you from doing bad things to other people because you may feel bad about it. That's effective as far as it goes, but obviously not effective enough to completely govern a society, because there are people who have no conscience at all or a weak conscience and will still do bad things. Second party punishment is if you did some harm or crime to me, I would retaliate directly against you. So you hit me, I hit you. That's second party punishment. Third party punishment is if you hit me, some third party, some not me, but some third party comes and punishes you for that. That's all that existed for thousands of years, right? Which can create some problems. So one of the problems that comes out of that is we quickly get to third party punishment, which is usually like kin, or like if a child is injured, the father goes and inflicts third party punishment, or a family member is injured and the family goes on the retaliation. So you get what is like the Hatfield and McCoy, family blood feuds that take place, which is very disruptive to society. So that third party punishment model, because of the problems created out of retaliation, revenge, blood feuds, gets removed then to the government once the government structures start taking place, or it might have been in early societies removed to like a tribal council or something like that. So that starts to look like a formal legal system, which we would start to recognize today, right? So over time, hundreds of years, maybe thousands of years, this develops and gets more formalized as it goes along. You start to have what looks like trials. You start to have incarceration rather than just execution. But a lot of the early punishments were you would just be killed for most things. So there was early days, there was no need for incarceration. They just killed you and we moved on, right? Or mutilation was a popular punishment. It's very punishment based. So once we start talking about individual rights, trials, then we got to hold people for their trial or keep them somehow in the community so they can be tried, which develops the need for jails. Jails are expensive, hard to maintain. So that leads to, well, can we release the guy pending the trial? We only have one judge and he's only here once every year. So what developed is this thing called a wargeld, where the defendant or someone on his behalf would put up an amount of money that the king or the leaders decided was just compensation for the family or the victim. And then if the person disappeared, that wargeld would go to the victim for compensation, thereby ensuring some measure of justice. You can see then that wargeld then becomes a bail bond over time, develops into that, even to be formalized into like commercial bail bond systems in the 20th century. So that's sort of the history of why and how that has developed. But then you have the question, which we answer every day in court, is what should that bond be? And that's the balancing of the order and chaos.
Yeah, and sort of this sort of third party, and we talked about this a little bit in our previous podcast about retributive theory of justice, but this third party punishment system sort of developed in coincidence with bail and the bond mechanisms. But I think most people understand this, but the benefit to that third party punishment system or consequence system, whatever the consequence may be, is that it takes that sort of chaos out of, right, the sort of doling out punishment, like you mentioned, the Hatfield and McCoy feud. It takes that sort of unrest away because you're sort of giving that authority or that task to a third party to carry out. Is that a fair characterization of what's going on? Yeah.
Okay. I think that's exactly what it's for, right? And it requires, though, a very high trust organization to be the third party punisher. The society has to agree that this is a legitimate arbiter, which is why we really have to pay attention to the standing in which our judiciary is held within the society, because if that breaks down, then you lose this entire justification for third party punishment, and your system devolves back into internecine warfare.
Yeah, right. And just, I think, to be clear for the listeners too, you mentioned this distinction between bail and bond, and often they're used interchangeably. So bail is typically going to be the money that is used to get the person out of jail, to get them to buy their freedom, at least while their case is pending, correct? And then
I would call bail the act of the release.
Okay.
You're bailing out, right?
Right. It's not necessarily money.
But it doesn't have to be money.
Right.
Frequently is. I believe money is a very good proxy for this, because it allows the judge to control the levers control the mechanism, order and chaos, better than almost anything else. That's a different podcast.
Yeah. But bond is really, as opposed to bail, is a binding agreement or arrangement of some sort. It's not the money or the property or whatever it is that's bailing the person or releasing the person from jail. It's additional conditions or some other agreement or mechanism that's binding on the person.
It's so bond is really either the person or a third party. Frequently think of it as like bail bondsman, right? But they're putting up an agreement. It's really the agreement to pay this money if the person doesn't return to court. Yeah.
And this is sort of a tangential point, but it's different. So a lot of people will have heard of a bail bond or bond in the context of the criminal justice system, but they would also have heard of the financial instrument, a bond. But these are two totally different concepts, and I assume they didn't evolve sort of at the same time. They're two totally separate concepts and have different evolutions as concepts.
Yeah, related to some degree, but not. Yeah, the history would be pretty different.
Yeah. Okay. So we've got this history. You talked about war guilds. In this sort of, these war guilds evolved into the more modern day bond systems or bail systems. How did the rise of individual rights like the Magna Carta, the English Bill of Rights, and later the Constitution shift this balance that we've been talking about from the beginning of order and chaos and the treatment of bail?
Yeah, so I would say the farther you go back, the more on the order side of the spectrum things tended to be. In terms of the aim of the justice system was almost entirely order, almost purely punishment. Then I described the things that made it necessary, some of the individual rights that made it necessary to have jails and war guild and bonds so you can ensure the person's around long enough for the traveling judge to get there to have a trial. So I mark the beginning of, in this series, what I call the rise of individual rights. I mark it by the Magna Carta, which was 1215. There were things going on before that, but just as a general marker, the Magna Carta is sort of recognized as the beginning of the rise of individual rights. So you have this period of the Middle Ages, which we think of as, and rightly so, as war and conquest. We have all these TV shows about the Middle Ages where it's just battles all over, particularly Europe, and it seems chaotic, and it's the rise and fall of kingdoms and all this stuff. But at the same time as that was going on, there was a development of individual rights occurring. It just took 1,000 years to really develop, or hundreds of years. So I say that let's mark that as the Magna Carta in 1215, and really the apex is the U.S. Constitution in 1789. And so by the time we get the U.S. Constitution, we have enshrined very seriously a lot of individual rights, many of those drawn from the English Bill of Rights, Magna Carta. Those things that existed are formally codified in the U.S. Constitution as kind of the peak of individual rights.
And you mentioned throughout the article the examples like the first Statute of Westminster, which was from 1275, and the English Bill of Rights, which identified, at least in the case of the Statute of Westminster, certain offenses that were bailable, and in the case of the English Bill of Rights, this concept of excessive bail, where it says excessive bail ought not be required. And then, as you say, the U.S. Constitution, sort of the penultimate sort of formal recognition of individual rights, with the Eighth Amendment, adopted this excessive bail language from the English Bill of Rights. Could you tell us a little bit about that? What does the Constitution say? What does the Eighth Amendment say in particular about bail?
Yeah, so I like to think I think it's helpful when you think about things, anything, is one framework to put on it is what is this eventuality? What problem is it trying to solve, right? And so if you go all the way back to the Magna Carta, it's one of the first formal instruments to talk about the right to a trial by jury, which is trying to solve for the tyranny of bad kings that you see in the early Middle Ages, right? And so individual rights is a response to no individual rights and oppression from kings. So the king can't just summarily execute you. Now you're going to be entitled to at least a group of people to say, yeah, this is just or not, right? So it takes a long time for this to develop. So 1275 is the first Statute of Westminster. The jury trial right gives rise to, we have to hold people until the judge can get there. That went on to subjects of the king. They had sheriffs back at that time. You had this problem of sheriffs taking bribes or to release people. So the first Statute of Westminster tried to solve for that problem. You have a right to a jury trial. You have a right to release, but we have to bribe the sheriff to get that to happen. So they take that out and they say, bailable, all offenses that are enumerated by statute, this first Statute of Westminster, are going to be bailable. So sheriffs can't have that arbitrary decision-making power. We have a statute now. That survives, but it doesn't address the amount of the bail or the bail bond or the terms of bail. So that has never really been solved. That question. It's always been the discretion of someone, now judges. But you see the English Bill of Rights of 1689 adopts language that says bail cannot be excessive. So it's trying to solve for that second problem. That's okay. We're not going to let sheriffs just hold people indefinitely. You have a right to bail under this statute. What should the bail be? The English Bill of Rights says we don't know, but it can't be excessive. And then the U.S. Constitution adopts that language in the Eighth Amendment. But it's important to understand there is no right to bail either in the Statute of Westminster in 1275, in the English Bill of Rights in 1689, or in the U.S. Constitution. There is no constitutional right to bail in our Constitution or historically for all of time. There is a statutory right to bail whenever a legislative body says you can bail on these things, but they don't have to say that. If they do say that, then bail just can't be excessive, whatever that is. That's the only U.S. constitutional right that exists with regarding bail.
What do you say to the argument that the Eighth Amendment, by saying excessive bail shall not be required, implies a right to bail? What's your argument there?
I think it does. I would say it doesn't imply a right to bail. If you read the history, those are two different things. What the history indicates is if there's bail determined by elected representatives or parliamentary body, then bail can't be excessive, because what they're trying to preserve, obviously, I think, is there are things you would not want people to be able to get out of jail on at all. And we preserves some of that today with murder, although there's a lot of procedures built in to hold somebody without bail in murder. But in Indiana, for instance, you could hold people without bail for murder and treason. So we want there to be circumstances where you can hold people without bail. And we have wanted for 1,000 years a legislative body to decide which of those offenses you can hold and which you can't. And when they do, then that triggers the analysis on whether it's excessive or not. But until then, that's not implicated.
And this gets into textualism and originalism to some degree as well, right? And in the other bills, in the other Bill of Rights, like for instance, the First Amendment or the Second Amendment, the drafters explicitly said there is this right that shall not be infringed, or they said, they named the right. Of course, that doesn't mean there aren't other rights, but you could say that the Eighth Amendment, if they had intended a right to bail, they would have included the right to bail in the plain language of the amendment. And then so that's the sort of the textualist argument, right? Then there's the originalist, which gets into the sort of the historical narrative that you've been talking about, that you have to interpret the language that they used based on the history of the time and the sort of the foundational environment when it was drafted.
And to go beyond on the textualist, you can point to other constitutions, like state level constitutions, for instance, Indiana's constitution, that does specifically give a right to bail. So it's perfectly capable of writing that if that's what you mean.
Right. One thing that you point out in your articles is that, the Constitution really doesn't say much about bail. And I was thinking as I was reading your articles, why does the Constitution say so little about bail? And I have a little bit of a theory. It's not a well thought out one, but I'd like to get your thoughts on it. So at the time of the founding, the Bill of Rights was intended only to apply to the federal government, and the federal government had very few crimes. And so that, I think that the founders may have thought that this was going to be primarily a state issue because most crimes would be dealt with at the state level. And so that may be part of the reason, at least, why the Constitution says so little about bail. Do you think that has any part of it, or am I totally off base there?
No, I think there's two things, and I would make two arguments, and I think they're related. One is your argument there, and I think most of the federal crimes that did exist were very serious crimes, right? Like treason, offenses against the federal government. So you probably don't want bail in terms of a treasonous actor or something like that, right? So makes perfect sense that they would not want to grant people the ability to get released. Most crimes, of course, are state level crimes. I think part of the thinking is we need to preserve those, through 10th Amendment, push those decisions down to that level and let the people, through their representatives, decide what's bailable and what's not. What level of chaos or what level of dangerousness are they willing to tolerate in their community? They need to make that decision. And they did. I mean, we do. You make that decision through state legislatures, through our state constitution, and all the way down to trial level judges making bail decisions. Like, that's how it's worked. So it reflects, I think, the difficulty it reflects an acknowledgement that these decisions are best made closest to the people that are impacted.
Yeah, I totally agree. I think that's the way they viewed a lot of things, right? Not just bail. And I think there was a lot of wisdom in that. And in lots of ways today, I think we would be well served if we got back to that sort of mindset.
Totally agree with that.
Yeah. So after talking about this sort of evolution of the bail and the way that it's treated by the Constitution, there's really not a whole lot happening at the federal level, at least, with respect to bail. But then you sort of get into this in the 20th century, these various reform efforts. You talk about the Manhattan Bail Project, 1966 United States Bail Reform Act, the Hart Committee, 1984 Bail Reform Act, and then the more what we would call modern bail reform movement. Right. And the response to that. Could you unpack some of that and sort of how we get from the Constitution to sort of these modern bail reform movements?
Yeah. So you have the adoption of the Constitution, and then, like you said, not much happens, and then it really starts to get active in the 1960s, really, which a lot of our politics went kind of haywire in the 1960s for some reason, right? So you have this real movement on criminal justice reform, bail reform in particular, that culminates back then in the 1966 U.S. bail statute. And that statute explicitly prohibited judges from considering dangerousness at all in making bail determinations. All they could consider was whether you would return for trial or not. So you could have someone a judge thought was very, very dangerous, but could not factor that into whether they should be released or not. I argue predictably that led to a rise in crime because you're releasing dangerous people back out on the streets. That is what happened. Now, people would argue there are other factors that contributed to the crime rise, but you referred to the Hart Commission, which was a commission that was put together by Congress because Washington, D.C. at the time became one of the most violent places in the country, and they had adopted, they were following this 1966 bail statute, partially because the district is unique because it's a city, it's a municipality, but it's governed to a high degree by federal statute. So the Hart Commission develops in Washington, D.C. because the Congress is situated there and they could pass laws for the city. So they developed this commission to study bail. They found that a very high, I can't remember the percentages, but an extremely high percentage of people that were being released were reoffending on violent offenses. So they implemented the first preventive detention statute that said you can keep people without bail. So basically repealed the statutory authorization for bail in the first place and put back in that judges, if they are going to consider bail, have to consider dangerousness. That drives crime down in Washington, D.C. You end up later with the 1984 Bail Reform Act, at the beginning of Reagan's second term. Reagan runs on law and order, restoring, getting rid of crime, because you had from the 60s through the 70s high crime in our cities. I know all this probably sounds familiar to today. We'll get to that part, but Reagan runs on restoring law and order. That culminates in the passage of the 1984 U.S. Bail Reform Act, which then specifically reauthorizes judges or specifically requires judges to consider dangerousness. So it's basically the Hart Commission D.C. statute writ large for the entire federal system. States follow those political and policy machinations. I argue in the piece that Indiana is typically a lagging state that lags the national trends, so they don't get around to reforming our bail laws that had been weakened or become more progressive following the 1966 federal law. Our state, I think, does it in like 1996, so we're about 10 years past the Reagan reforms before dangerousness is put back in Indiana's statutes. So those trends that pendulum has been swinging sort of back and forth since the beginning of the 60s. And we've seen that those political winds blowing. And then we had what I call a third wave of this that we're currently living through.
Yeah. So we have like this civil rights movement that sort of begins right in the 60s. And there's this move if we go back to our original framework, right, toward more chaos by releasing more inmates because the judges are only supposed to consider whether or not they will appear for trial. And then that sort of takes out of the judge's toolkit or considerations anyway, the potential dangerousness of that person. And of course, there are lots of arguments for that position when the 1966 United States Bail Reform Act was adopted. And I want to get into some of those arguments because, as you say, there was this reactionary response in the 80s because crime was on the rise to more order and to giving judges more discretion to consider other factors other than just whether or not the defendant would appear for trial. So if you would, could you break down some of the arguments for the people who wanted to err more on the side of release or freedom than pretrial detention? I know you mentioned the equal protection argument, this presumption of innocence, which is always an argument that you hear about, and then whether or not dangerousness is an appropriate factor to consider. Can you talk about what the reformers have in mind when they are advocating for more liberal pretrial release?
Yeah, so the first one I talk about in the piece is they argue a 14th Amendment equal protection violation. So if you have two people that commit the same crime, one of them is rich, one of them is poor, the rich guy can get out, the poor guy can't. That's an equal protection violation. They are relying on the application of the Eighth Amendment, saying that's the right that's violated. As we've talked about, there is no right to bail in the U.S. Constitution. So, and U.S. Supreme Court cases throughout history continue to affirm that there is no right to bail in the U.S. Constitution. So while that can be a persuasive argument, it might be sympathetic, but it's not legally sound. There is no constitutional right to unequally apply. So there is no equal protection argument to be made. And the court cases throughout history confirm that. So it's made. If you don't take the time to really understand the history of it, then it can be persuasive. The second argument people make is that if we're presumed innocent, how can you be held pretrial? The presumption of innocence should mandate release. Presumption of innocence is an analytic framework for trial. It's an instruction to juror or the fact finder, but typically jurors, on how to think about whether the person is guilty or not guilty. It does not apply to bail determinations. And there are Supreme Court cases that say presumption of innocence does not apply in bail determinations. Despite that, I hear in court frequently in front of me in bail arguments that the person's presumed innocent, and that's just not accurate. They're in fact presumed guilty to a probable cause standard. If you didn't have that, just theoretically, if you didn't have I agree that probable cause is a very low burden, but if you didn't have some kind of presumption in favor of guilt, you would have no authority to have any terms on the person at all, no infringement on their liberty. So you have to have made some kind of finding that they've broken the law in order for a judge to have the authority to put any conditions on them whatsoever. So this idea of presumed innocent is in contrast to the judge's authority to put conditions. You have to have at least that initial trigger of presumption that they've done something wrong.
And I know this is not the framework that courts have used historically, but the way I think about it, at least to make it make sense to me from not just a legal perspective, but a natural rights perspective, is that there is a presumption of innocence, but there are different thresholds or levels that you have to overcome to defeat that presumption at various stages of the case.
Absolutely.
And like I said, that's not the way the courts have historically looked at it, but that's the way it makes sense to me.
Yeah, and at the pretrial stage, the level is probable cause.
Probable cause.
So I would be fine with an analysis like that. I think it has the same ultimate effect. My analysis is always the presumption of innocence doesn't trigger until trial. But either way, I think you and I probably arrive at the same place on that.
And then the last one, before we move on to the last one, I'm going to go back to the equal protection argument for a moment, because some advocates for a more liberal bail approach, for the record, I've never heard a progressively inclined political person, or not a classical liberal, but a modern political liberal. Never heard them argue about the Ninth Amendment. But the Ninth Amendment, right, is a sort of this catch-all that is meant to protect unenumerated rights. And so they could theoretically argue that, bail's not explicitly laid out as a right by the Constitution, but the Constitution recognizes that there are many unenumerated rights, and they could argue that bail is or should be one of those. Do you have any sort of counter argument to that?
Well, so I've not read Ninth Amendment arguments. There is that people do make substantive due process rights arguments, but it's a very similar argument that there are rights within the Constitution that are not enumerated, and there's substantive due process rights versus procedural due process rights. So, and some of those have been created. I do address that in the piece, that the court has never created a substantive due process right to bail either, and they've never said that the Ninth Amendment creates a substantive or a Ninth Amendment right to bail either. So it's never been said. Certainly, a court that's inclined to, a more pragmatic court or a living constitutionalist court might certainly seize on that and create that right. But so far, it's not been created. I don't think it would also be contrary to thousands of years of history and tradition.
And then the last argument is just this concept of dangerousness, that this should not be a factor. Why are they saying that? Is that tied into the presumption of innocence, or is there some other motivation there for saying that judges should not be able to consider dangerousness?
Yeah. So, well, I think the motivation is that if you could start considering dangerousness, you're going to hold people. So we want to look for a way to avoid dangerousness altogether. Part of what kicked off this 1966 movement is there's a 1954, I think, mid-50s U.S. Supreme Court decision called Stack v. Boyle, where I think it was the Chief Justice Vinson, but I may be wrong about that, but rights that in dictum, the case doesn't really turn on this, but just as a throwaway line in there somewhere, he writes that the only proper consideration for bail is reappearance at court. I get motions to alter bail terms today that cite Stack v. Boyle. I think the Indiana Public Defender Council's stock motion that they recommend cites Stack v. Boyle for this very proposition, and it just simply is not the law. It's dictum in a case that didn't turn on that. It was actually a habeas case, and the judge just kind of tossed that in. But then there's a case a few years later called Salerno, where William Rehnquist writes about Stack and says Stack that's nonsense, that dangerousness is of course a consideration, that extraneous language in Stack is the way he phrased it is too slender of a reed to hang that argument on. So it's not only dictum, it's been categorically rejected by a later decision of the Supreme Court, but it's still alive. It pops up frequently because I think there's a real desire to get dangerousness out of the conversation on the part of some people.
Yeah. And is that because, I mean, we were talking about motivations, and part of this is speculative because people have various motivations. So it's hard to generalize in this regard. But is it, I know some people say, well, we don't want judges to have this sort of arbitrary authority to make a finding of dangerousness and set bail at such a high level that nobody can post it. And then we're just incarcerating too many people pre-trial and many people who may be innocent. There's that sort of argument. What other sorts of arguments do you hear against this ability to consider dangerousness?
So there's always the disproportionality argument that minorities get held disproportionately. There's an implication of racism about that. There's also the implication that people with fewer means are going to get held disproportionately, which certainly is a factor. And I think we'll get to that too. We talk about that some in the piece. So I think those things can be cleared up. I don't think they're legitimate arguments, but those are some of the arguments that are made. I think the arguments don't work because once dangerousness is in the equation, part of my argument is dangerousness is not only in the equation, it's been the paramount, fundamental first aim of this whole process from the very beginning. But once it's in the conversation, it makes it really hard to release some people. Now, can judges be too quick to find dangerousness and hold too many people? Sure. But I think, and you probably agree with this, that the check on that is the local political process, that the people who are impacted in that community think the judge is holding too many people in jail and causing too many people to be punished too harshly or lose their jobs or whatever, that judge will become politically unpopular and lose the election, and the different judge will probably take the hint, right? And so the remedy, I don't think, is let everybody out of jail. I think most judges are going to do a good job. Like we said, most people are going to live in an established order of their own volition without the government influence. Most judges are going to do a pretty good job making that calculation based on their judgment, interacting with the people they live with in their community. But if they don't, and there are bad judges from time to time, then I think there's a process for dealing with that. And then there's also the ethical process. If a judge is doing something, if a judge is being racist or being discriminatory against low-income people, there's an appellate process, there's an ethical disciplinary process, and there's a political process to deal with that. And I think those things catch the problems almost all the time.
I love this point that you make on page 24, and page 24, I shouldn't say that. That's the way I printed it out. It's page 24. It depends on your computer how it may print out, the formatting. But it's in this section where you're talking about dangerousness and why ignoring dangerousness won't cure this inequity problem. And I'm just going to read this quote because I think this is a great example. You say, how does ignoring dangerousness cure inequity? To be more explicit about this, it is surely the case that if a dangerous person has enough money in a pure money bail system, he may be able to secure his release pre-trial, where a poorer person could not. Such a scenario certainly represents an inequity, but this is an argument for preventative detention of the dangerous rich guy, not for pretrial release of the dangerous poor guy. Yet bail reformers fight tooth and nail against procedural reforms like preventative detention. I love that section there because I think that gets at exactly the point. It's a good rebuttal of the point that a lot of reformers are making, is that the remedy here is not just to release everybody, or even if they're dangerous. It's hard to prevent these inequities, but releasing dangerous people won't fix it.
Well, it's always bothered me, built into that argument is some kind of premise that's never stated from the other side of this, that somehow the people that are kept in jail are innocent, which is not the case, right? At least there's been a probable cause finding, right? So it's always been bizarre to me that we would release a guilty person in order to have our ledger sheet at the end of the day balance out with the right demographics or something. What I would prefer is we just keep all dangerous people, regardless of their socioeconomic status or minority status.
Here's another theory, at least I think motivating part of these arguments, is that I think a lot of the reformers disagree with many of the laws. For instance, they may not think that people should be incarcerated for certain drug crimes. And they think that the remedy for that is to make bail conditions easier to obtain or make release more liberal. But the remedy is to change the law, right? Not to make it easier for everybody to get out. And I've never actually heard that argument, but that's just me sort of intuiting some of their motivation anyway, that they think the law is unjust, and so that people incarcerated for those laws, it should be easier for them to get out. And so we want to address that through bail because that's easier to do than changing the law. Do you see any of that?
Yeah, well, yeah. So I write about that. It was I think we'll get into this in a little bit, but it was a specific aim of the Obama administration under Attorney General Eric Holder to take these reforms not through the Congress or not through state legislatures, but to specifically try to influence state level judicial actors to do this, to do the very thing you're talking about. They made the assumption, and they were correct. I mean, they were very successful at it. They were a very successful group of people. They made the determination that it would be easier to influence judiciaries than it would legislatures. And they were right about that. It was very effective.
Actually, now's a good time to go ahead and get into that. Just to preface that, my understanding is that movement was motivated by disagreement with the law surrounding bail or pretrial release, not so much disagreement about other laws, the underlying laws for which the person was incarcerated. So I think there may be, at least in my view, there may be some motivation on both ends of that they don't like the law about pretrial release conditions or bail. They also don't like that people are incarcerated for certain types of crimes. And so that's another motive.
Yes, I agree with that. It was a broad movement. I'm focusing, this just on the bail piece, but there was juvenile justice reform as a part of that. There was efforts they did make aims at legislative changes, but the part I'm focusing on is the aim that they took at the judiciary, which was mostly the bail issues.
So you mentioned the Obama administration. If you would go ahead and tell us a little bit beyond sort of these legal arguments we've been talking about, how did the sort of modern reform movement, where does it have its roots? And obviously in your article, you argue that's with the Obama administration. Can you tell us a little bit about that?
Yeah, I traced that, all these things bleed over time, right? So there's no definitive date, just like the Magna Carta is not definitively the rise of individual rights, but you got to start somewhere. So I traced the beginning of this to 2012. Eric Holder, President Obama's Attorney General, sends a letter to all what they call state level judicial actors. So Supreme Court, or state Supreme Court justices, appellate court justices. I'm not sure if it included trial judges or not, but they send out this letter from the Department of Justice laying out all these arguments for why people should not be held pretrial, and they use the Equal Protection Clause arguments, presumption of innocence arguments, the inequities, racial and economic disparity arguments. And they put all that in there, and they encourage state-level judicial actors to adopt rules and procedures to move to cashless bail or to make it more difficult to keep people in jail pretrial. And then they funded and developed and populated trainings for all these state-level judicial actors over years, where state-level appellate court judges go to the National Appellate Court Judges Conference or whatever. They did a lot of it through the National Institute of Correction, I think it's called, NIC, and they train on this stuff, and then those state-level actors bring it back and then implement it by various means at the state level. Indiana, which ended up being on the vanguard of this movement, even though we're a conservative state, traditionally didn't favor those kind of things. I talked about Indiana traditionally lagged by a decade the political machinations at the national level. This bail, our judicial system really took up with fervor and was one of the leading edge of bail reform in the nation by court rule. So it was a little unusual for Indiana to take those arguments. One, because we traditionally lagged. Two, because we're conservative state run by supermajority Republicans in our legislature. The governor was a Republican. Every Supreme Court justice was appointed by a Republican governor. Yet they're adopting the Obama administration's policies. Not that there's anything necessarily wrong with that, but it does stand out as an unusual thing for an Indiana court to lead on. So when I say that the Obama administration was successful, they were extremely successful at that. So they started in 2012, but then we had this wave of wokeism and rise of wokeism, and then which really crescendos in 2020 with the George Floyd situation. So the administration was ahead of the curve on all that and really benefited from that political movement that washed across the country during that time. So they were very, very effective. It's hard to tease out whether they were the cause or the effect or benefited from what was naturally going to happen anyway, but I do give credit to that administration for how good they were at getting their policies implemented.
Yeah, and obviously people who listen to this show know that I talk a lot about the Second Amendment and the right to bear arms. They took that tactic and implemented various gun control measures in that way too, rather than through legislation using various political arms or executive branch agencies to sort of implement policies through sort of influencing state and local officials to implement those policies. And whether you agree with it or not, obviously I would disagree with their policies. They were certainly effective at doing that. And this is, I think, a corollary to that, at least in the bail, the pretrial release mechanism. And we're talking about Indiana, sort of one of the manifestations of that in Indiana when it was considering bail is that when Indiana created Criminal Rule 26, this created a presumption of release without bail, right? And emphasized this risk assessment tool that only screened for flight risk and not dangerousness. So that was sort of the implementation of this policy at the state level, right?
Yeah, and I hope the article I wrote sort of, by the time you get to this part about what Indiana's doing in response to the Obama administration, I hope you're seeing reflections of the 1966 movement. So what Indiana did with Criminal Rule 26 was de-emphasize dangerousness, which is what they did in the 1966 movement. They put a presumption in favor of cashless release, which was part of the 1966 movement. They start screening for reappearance rather than danger to the community, so the risk assessment tool doesn't address dangerousness. So you see echoes of that movement reappear now in this movement, and our court, by rule, adopting those same things. And
there was, ironically, the timing is about right as well. I mean, from 1966, from the Bail Reform Act to 1984, that's 18 years. From 2012 to 2025, we're approaching that 18-year mark, and we're starting to see, the pushback to that sort of reversion back to that reform mindset.
Yeah, and I want to point out too that this Indiana had existing bail statutes from when I talk about the 1996 Indiana bail reform law that followed the 84 Reagan Revolution, and the court, despite those statutes, implements this rule, implementing all this bail pretrial reform, which I would argue should have gone through the legislative process, not by court rule. But again, the Obama administration was encouraging courts to do this because it was more difficult to get through legislatures, especially Republican supermajority legislatures.
Yeah. And of course, we're seeing a lot of the backlash today. And one of the most recent examples was the tragic murder of Irina Zarutska on the public transit in, I don't remember what type of transit it was, but on the public transit system in Charlotte, North Carolina. She was stabbed or sliced in the neck by a guy who had been in and out of jail or prison on many occasions, and I think was on pretrial release at the time of the incident. You may know more of the details about that, but there are numerous examples like that, and I think a lot of pushback is starting to occur with respect to these pretrial release reforms.
Yeah, so just like you had the 66 and then this more modern version looked like 66. Now we're starting to see 1984 U.S. bail reform pushing back the other direction. That's starting to happen now again. And of course, the reason is when you let dangerous people out of jail, they tend to commit more crimes, right? And the people in the community don't want to suffer those crimes. They start looking around like, why is this happening? And they notice that judges are letting dangerous people out of jail, and they get fed up with it. And so then there's a political backlash, and we're starting to see that. But it's certainly not, the reform movement's alive and well. For instance, just this week, Monday, the Indiana Judges Association testified at a hearing on bail. An interim study committee of the legislature testified in favor of cashless bail. So there's still a segment of the Indiana judiciary that's in favor of these reforms or reforms like this. But on the other hand, there's coming up in the legislative session in 26 a statute to allow preventive detention in Indiana for violent offenders. So you got all those things sort of in the mix. It's never a straight line, right? But we're certainly seeing some indications that it's moving back the other direction at the state level, and certainly at the national level. The Trump administration has been very adamant that they're not in favor of cashless bail, and those policies need to be restored, and they're threatening to revoke federal funding in states that follow those more lenient pretrial release programs. Things like the stabbing in Charlotte are why, those high-profile things. So we'll see where that will. Stay tuned, right? I might be in a position to write some follow-up on it and see how this movement goes.
Yeah, and of course, getting back to our original framework that we discussed at the beginning, this order versus chaos, the goal is not to incarcerate everybody, because obviously, right, we could have a lot less crime and more order if everybody were in a prison, right? But that's not what the sort of the reaction to these reform movements is advocating, right? It's just saying there needs to be more discretion for the judge to consider dangerousness when making pretrial release decisions to help balance that order and chaos as best as we can. It's not a perfect system either way, but releasing dangerous people is also not a good option.
Yeah, and so what I sort of wrap up advocating for in the piece is dangerousness is a consideration that has been paramount since the beginning of human societies. 1966, we decided that didn't make any sense anymore, and in 2012, we decided that didn't make any sense anymore. Both times have resulted in more crime, more violence in our streets. Those are two anomalies for a short period of time set against thousands of years going the other direction. So I suggest, as a conservative, the idea that's lasted 5,000 years is probably a better idea than an idea that's lasted 10 years, especially when the 10-year idea has resulted in death and carnage and violence and blood in the streets. My advocate, let's let judges consider dangerousness. If judges are too heavy-handed, I think if they're too heavy-handed, there'll be a political solution to that. If they are discriminating, there are appellate and ethical solutions to that. I think judges are going to do a good job with that determination. That's literally the judge's job. So let's just let the people keep an eye on their judges, and if they don't like them, they'll get different judges. Right?
Yeah. Before we close up, and I'm going to give you an opportunity to make any other parting thoughts that you'd like to make. You mentioned that there's studies that show that bail reform is implicated in rising crime, which seems intuitive. It seems like common sense that would be the case. But you mentioned that in cities like Chicago and Indianapolis, there are studies that show that there is this implication of bail reform in rising crime. Can you tell us a little bit about what those studies?
Yeah, and I linked to them in the piece, so if people want to go look at it, you can actually go to the actual studies and look at them. But basically, you have, in most cases, you have definitive dates where the law was changed. So they just take cohorts, they follow releases from the date of that law change and compare it to prior years and see how much reoffense is occurring, what the recidivism rate is of the population that's released. And so it's not a complex study. It's fairly straightforward, and they are able to show more crime occurring from people who are released post reforms versus prior reforms. And so studies are one thing, but I also point to, and maybe is more important, for instance, New York as a state implemented cashless bail for almost all offenses. Crime went up. They had They had a governor's election and congressional elections in 22 after that occurred. So I think New York did it. I'm not sure the date, but the 22 election cycle, the governor almost lost. The Democrat governor almost lost to a Republican, and 7 U.S. Congress people who were Republicans won in Democrat seats. And the number one issue was crime, and the number one issue was pretrial release. Following that election cycle, New York reversed their cashless bail laws. So you have the studies, but you also have, maybe even more important, the free market, the political free market responding, which is evidence that these things were the cause of this more violence. So I believe the data points are there to indicate that this is a problem, and we're coming to the same conclusions that we came to with the Hart Commission and the 1984 political movement. I think the evidence is pretty strong.
Judge, well, I really appreciate your time today. I want to give you an opportunity here at the end to just make any closing thoughts or parting thoughts that you'd like to make, and obviously take the time to plug your Judex and any other resources that you'd like to plug.
Yeah, well, thanks again, Alex. I really enjoy having these conversations with you, and I hope people will take away that we try to make a very thoughtful approach about it. One of the risks of talking about this is you sound like some kind of mean jerk who just wants to put everybody in jail, and that's not. You and I share a philosophy of individual liberty, and I value that strongly. But I think that dangerous people have to be controlled, or our personal liberty is at stake. And so the reason for the piece is to encourage people to consider the importance of dangerousness and the historical value and the necessity of considering dangerousness when you're making these decisions. So I hope it's persuasive. If people want to read it or anything else, I write on a variety of topics, as you mentioned. It's Substack/Judex. Can go to that website and subscribe, or just go and check it out. But I'm glad to have that, and I'm glad to have the opportunity to have these conversations with you. So thank you.
Well, thanks a lot, Judge, for coming on for the conversation. I really appreciate the work that you do at Judex. I enjoyed your series on making bail, and I'll be sure to link to that. I'll link to all the separate installations as well as the compilation so that people can consume that however they like. And of course, would encourage people again to go back and listen to our previous conversations if they haven't already in episode 27 and 103. So thanks again, Judge, and thanks again, everyone, for tuning in. Be sure to join us next week. I'm going to be discussing a Supreme Court case, Nome v. Perdomo, which is an immigration case that could have profound implications for gun owners. Justice Brett Kavanaugh recently suggested that an agent could detain someone based on their race, accent, and location. And we'll discuss why this could be a dangerous precedent and how it could be used to justify mass detentions of law-abiding citizens, such as everyone attending a gun show. So look forward to that, and I hope you'll tune in for that. We'll explore whether moving away from this sort of individualized suspicion toward a more standard based on group probabilities is a step toward a freer society. So I hope you'll tune in for that, and until then, remember, you are the forge of freedom.